talk you through about how I assembled this data set and the method of analysis used, especially to extract the citations. And then I will talk you through some results. And this is actually part of a book I'm writing at present. So I'll just then conclude my remarks tonight by outlining this in the context of the other chapters of the book to sort of see, so you can appreciate the overall sort of project that this is part. So first of all, what I'm looking at is especially trying to evaluate the guidance value of case law, the extent to which tax law is inherently a legislative topic. So we get the liability to tax from legislation that is enacted, but to what extent case law provides value in clarifying that. And then the sort of subsidiary question then is, to what extent can we identify which litigation is likely to be cited in the future? Because then if we can, litigation has a cost to it, both to the individual and to the state. And so if then we can see that not all litigation is likely to be of a guidance value, if we can identify what legislation is, then that informs which litigation should be encouraged. And then this has a broader value in understanding how data analytics in litigation can work. Because definitely in the UK, and I understand also in Australia now, lots of law firms are engaged in data analytics. So this project shows some of the potential for it and some of the challenges and also the limitations with applying data analytics to litigation. So the motivation for this, there are a number of policy reasons that make it important to understand the guidance value of litigation. First of all, costs in terms of whether adverse costs are awarded and whether we have a system that encourages or adverse costs. So it's interesting from the UK's perspective, when VAT was introduced in the UK in the 1970s, the policy was that HMRC would never seek to recover costs from the taxpayer, but the taxpayer would actually be allowed to recover costs if they were successful. And so this was because litigation of VAT cases was thought to be very important because it would help people understand how the system worked. When the new tribunal structure was introduced about 12 years ago now, that was reversed. And so we don't have that asymmetrical cost policy anymore. So that's by example of what costs should be. In the UK, we also have this very interesting legislation that you don't have over here in Australia about follower notices. So follower notices are a way where HMRC can discourage taxpayers from entering into litigation about issues they consider have already been determined by litigation. So when HMRC has a case before it and they consider that the principles or reason given by an earlier decision would, if applied to those facts, determine the matter, and it's an avoidance situation, they can issue the taxpayer with something called a follower notice. And that follower notice imposes penalties on the taxpayer if they continue with the litigation, and can also require them with an associated notice, an accelerated payment notice, to pay the tax up front. And those penalties are actually quite high. They were originally 100%, now they're around about 60%. And so the issue of follower notices was litigated, and it went to our Supreme Court in the case of Howarth. And there the Supreme Court decided that follower notices could only be issued where HMRC were sure that the principles or reasoning given of the earlier case would apply and deny the asserted advantage. And they said one of the reasons they gave for that was the principle of legality, and that litigation was important because it had a guidance value. And so, in understanding whether or not the Supreme Court were right there, it's actually an empirical matter, the extent to which litigation does have a guidance value. And so this, again, this research helps understand the guidance value of tax litigation. Another policy issue we have in the UK is whether or not tax judges should be specialists. And so recently, when we've been recruiting first instance tax judges in the UK, especially the fee paid ones, so the ones who are not full-time, it's been part of a general competition, and people have just been assigned to the tax chamber, some of whom don't have much tax experience, if any. And so the question is whether or not you need to be a tax specialist or not. And in the research I did for the IFS, the Miranda highlighted at the start, the tax tribunals the next 10 years, lots of advocates were saying, actually, you don't need to be a tax specialist. You just need to be a very good lawyer at interpreting legislation. But others were saying, well, you do need to be a tax specialist because it's impossible to absorb all of that knowledge quickly to get you up to speed to being a good judge if you're not. So again, this is one of the questions that's addressed in this, the extent to which there is a sort of body of case law that can be easily absorbed, or whether you just need to be a good lawyer and be able to pick up cases that are presented to you. And I address this in a later slide. And there's also a body of academic scholarship on citations that this plays a part of. So that's the sort of general context. So what I'm doing here is I've assembled an extremely large data set of tax decisions. These are around about 7,500 decisions of our first tier tribunal, which is like the AAT. And then I also have earlier predecessor tribunals. So the 746 decisions of the special commissioners who had direct tax cases, and the 11,500 decisions of the VAT tribunal. And then I also have the cases that have been appealed onwards from there. So 3,500 tax cases that were appealed to the superior courts and now appealed to the upper tribunal and then on to the Court of Appeal. It's a vast data set totaling over 120 million words. And so there are some limitations to this. So it's not all litigated tax cases, because not all first instance decisions are published. As I noted on the earlier slide, the special commissioners only started publishing their decisions in 1995, whilst the VAT tribunal had published its decisions since the 1970s. And also, even now, not all first-tier tribunal decisions are published, and around about 40% of them are. Others where there's seen to be no precedential value, often relating to confiscation of alcohol or penalties for late filing of returns, aren't published. So it's only around about 40% of the decisions which are actually published of the first-tier tribunal. Other textual data that I've got in this project are all the major tax statutes enacted since the 1920s, totaling over 11 million words. I use these because, as you'll see, I identify when a judge is quoting statutes. Another thing that we have in the UK is HMRC's manuals. So these are originally manuals by the Revenue Authority to their inspectors to tell them how to apply the law. But because of Freedom of Information Act requests, around about 20 years ago, HMRC just decided to make these manuals accessible to everybody. And so with these, I can see the case law that is cited in the manuals, so the case law that HMRC considers to be useful. And also HMRC has provided me with the website hits of each of those manual pages over a 2-year period. So I can see the pages that both inspectors, because they access the manuals on the web, and taxpayers, who are frequently turn to the manuals for advice, consider useful, or at least seek guidance from. And so, as I say, there are over 16 million unique hits of the manual in the year. And those are all from people who accept HMRC's cookies. So there will also be additional hits of the manuals, but unfortunately, I don't know who those. I don't have those because HMRC doesn't record them if you don't accept their cookies. So the method. What I'm going to take you through is the method I've used to create the data that I analyze. So converting and cleaning the document. So often the first tier decisions come in PDFs and they need to be converted and then cleaned. How I extract the citations, how I harmonize the citations. So what I want to know is whether a particular case is being referred to. But sometimes it will have a reference in a published series of cases, like Simon's tax cases. Sometimes it will have a neutral citation. And I need to make sure that regardless of how it's cited, I'm looking at the same case and then also only counting it once. How I extract quotations both of legislation and of previous decisions. And then I'm also going to address the issues of copyright and data protection, which are also important. So first of all, what I do is I need to convert the PDFs to text format. You can do that with a program quite easily, but then there needs to be slightly more advanced programming to join the lines where they should be joined, to join page breaks where they should be joined and remove page numbering between those pages, and ensure that paragraph breaks in the particular decision are preserved. Again, I wrote the program myself to do that, but it takes a lot of time. And again, identifying where the body of the decision starts and removing the stuff that's just the head note at the start of the decision. So I refer to all of that as cleaning and converting the decision. Then what I do is I identify the citations of cases, and I identify whether a case is referred to by whether or not there's a citation there. I do this by citations conforming to particular patterns. So in programming, there's something called regular expressions, which I can then use to, again, just extract these citations. Now, with the published series of law reports, that's far easier to extract these things because people have proofread them. Unfortunately, with the first tier decisions, there's often quite a lot of errors, but they're common errors. And so I've been able, through a process, to identify and correct these common errors prior to extracting the regular expressions. I've also, to just make sure that I'm extracting the correct citations, that I've validated this, because for reported decisions, you have at the start of the decision a list of the cases cited in the decision. And so to validate that my program to extract citations is correct, I've been, throughout the development of it, double checking it against what the list of cases is in the printed decision. And I've made a program that's very accurate to extract these citations. So as I say, what then you've got to do after extracting the citations is make sure that they refer to a unique case. And you can get multiple citations to the same case. So what I've done is I've created a thesaurus, a sort of dictionary to create where varying references to the case and know it all refers to a single case. And I did that firstly from looking at published decisions, where at the start of the decision, they normally list all the different citations of the case there and creating it from that. And also Westlaw practitioner texts have a table of cases at the start of them. And from that table of cases, again, they list each of the different citations of the case there. And I've been able to essentially scrape that data lawfully and create a thesaurus to then create a unique reference to any particular case that harmonizes those varying possible citations. I also, in addition to identifying citations of cases, I identify quotations from earlier cases. And I also identify quotations from legislation. So, as I told you, I've got this bank of legislation and I've got all the cases. And so what I use is these things called engrams. So engrams are contiguous sequences of words. So if I look at this phrase, quotations from earlier cases, and then I look at bigrams, bigrams are two words that occur one after the other. Quotations from is one bigram, from earlier is another bigram, and earlier cases is the third bigram there. Now, bigrams, things can occur by chance, but if I look at something which is longer, like a decagram, a contiguous sequence of 10 words, those 10 words are unlikely to occur by chance unless they're quoting something. So first of all, I extract the legislation and see when it's quoting legislation. And then I look for quotes from earlier cases because I order the cases chronologically in my data set. And so I can see quotes that are not legislation, but from earlier cases. And so therefore, I'm able to see the extent to which judges are either copying and pasting from their earlier decision or quoting from another judge as authority. And as I say, I do this because all of what I do is allowable due to exceptions in UK legislation from copyright for data mining for non-commercial research purposes, which is actually going to be extended soon to commercial purposes as well in the UK. And the reason I don't identify and name specific judges in my research is because if I were to do so, then it would put me in a more difficult position with regard to data protection rules. And then I'd have to start informing people that I'm processing data on them. Whereas at the moment, I fall outside that requirement. So just a few introductions to brief descriptive statistics. Looking at, as I say, HMRC's manuals and which cases are cited in the manuals, weighting the pages by the number of hits that each page, this isn't, weighting, yes, by hits that each page gets. And I've ranked each case from the one that gets the most weighted hits to the one that gets the least. And you'll see that like the most cited case gets like 30,000 hits. And then, but then the 500th case gets only around 2,000 hits. And so there is large numbers of cases, basically a small fraction of cases are the ones that provide the biggest guidance value. If you look at this shaded area here, the top 500 cases provide by far and away the most guidance value. And even if we look at the top 100 cases, you'll see that it really is like after the top 20, it starts to plateau quite a lot. So in HMRC's manuals, pages containing the top 100 most cited cases got in total just shy of 1 million hits. And in total, as I say, there were around about 3,600,000 hits of manual pages containing citations in general. So of the top 100 cases got around about more than a quarter of all the hits, essentially. So if going back to this question, how much do you need to know to sort of understand some tax? If you understood the top 100 cases, then that implies that you have a good knowledge of tax in general. And so this, again, then I wanted to address this issue a bit more in detail, the question of judicial specialisation. How many cases do you need to know to be a good judge? So this is, I'll go back to that slide in a second, but the report that Miranda referred to that I authored, Tax Tribunals the Next 10 Years, this is what one of my respondents to the report said. One of the odd things about tax is how much law there is and how widely it is spaced. So even on a difficult commercial court case, it's going to be quite unusual for a judge to be asked to determine a novel point of law based on cases that they have not even seen before. The difficulty is really going to be on the facts. If the commercial court judge has read the witness statement, they will know enough to be able to engage. But in a recent tax case, to engage with which one of us was right about it, on one of the three main arguments, the judge needed to read about 12 cases. That in half a day's pre-reading. Because you only allocated half a day, essentially, to prepare and read for a tax case like that. And so the question being, is that actually typical that you're required to read 12 cases to prepare for a tax case? So to do this, what I looked at is actually the cases that each of the judges at first instance had heard over the course of their career in the first tier tribunal. I did that because cases aren't randomly allocated to judges. Partly, some judges may express a preference to hear particular cases, and so reserve them to themselves. And partly, some judges won't be available to hear cases. As I mentioned, lots of them are part-time, and if it's a 10-day case, many of them won't have 10 days that they can allocate to hearing such a case. And also ticketing. So not all judges are allowed to hear cases. So salaried judges can hear all cases. But of the fee-paid judges, those are the judges who aren't salaried, they're in 4 different categories. And only the top category of them can hear all different types of cases. And then the 3 tiers below them can only hear a more limited range of cases. And that's why we want to look at the cases that the judges actually heard. So what I did was I got the cases, and the computer did all of this for me. It ordered them by the order in which the judges heard the case. Then it looked at cases and it identified the number of cases that were cited in those cases. And then it said, had the judge written a decision that cited any of those cases before, and what proportion or what number of cases had been cited by the judge in an earlier decision of theirs. And so I was able to calculate for each case in order, or at least each case in which a judge cited cases in their decision, the number of cases that were new for them. And so I did this for each judge, and then the graph that you'll see reports the median result for the judges. So the median result for a judge on their first case, or the median result for a judge on their second or third or fourth or fifth case. This will become a bit more evident when I show you the graph. So let's do that. So you'll see that on the first, second, third, and fourth cases, the median number of cases heard referred to in a judgment is 3. So in the first, second, third, and fourth, the median judge would refer to 3 cases. Then in the 5th case, it goes up. And so this is a feature of the fact that the longer your judicial service, probably the more complex cases that you're being allocated. And so towards the judges who are hearing more cases seem to progressively cite more in their decisions, I think as a feature of the fact that later on in their career, they're probably being assigned more complex cases. So then I ask the question, what percentage of those are new cases? And so generally for the median judge, on the first few cases they hear, they're all new because there haven't been earlier decisions. But then the grey bit shows that sort of excess. So the cases that they have referred to in earlier decisions. So the further they go along, on average, you'll see that that there's quite a lot of cases they're referring to that they have read before. But you'll see also consistently that for the median judge on their 60th or 80th case, there's still quite a lot of cases that are new, between 2 and 3 cases that are new on each occasion. So a process of learning. Now, I should say, this is, again, of the first tier tribunal in their decisions for this analysis. So there aren't, like, the newness isn't the case that has been being appealed. So there isn't anything like that to confound it. So the barrister I interviewed was right that there was always some element of newness in the and learning but by the tribunal, but it isn't the 8 cases that are new. It's not typical. So this is a example of descriptive statistics. And so then what I was going to conclude with was presenting you with some more sophisticated statistics on this, using a statistical model to show what factors make a case more likely to be cited as authority going forward, or less likely to be cited as authority. So these statistical techniques are taken from epidemiology. So generally the event is a bad thing. It's normally death, mortality that we're looking for, and hence why it's called survival analysis. Here we're using the same technique. It's just the event is a more positive thing, whether or not a case is cited or not going forward. And so what we can do is we can sort of sketch out how long it takes for a case to be cited, if it ever is going to be cited. And that's essentially the survival estimate. And then we can then also make a model of what factors, such as decision length, for example, that you'll see, make or a case, or the complexity of the case that I measure using a variety of means, suggest the case is more likely to be cited if it hasn't been cited yet. And that uses something called a hazard rate, which I'll talk to you about in a second. So basically, I'll talk to you about the easier thing, which is the survival estimate first. So if this, as I say, is the likelihood that the case has not been cited going after up to 10 years. So the blue is for the first tier tribunal decisions. The red is for all other decisions of superior courts. And so there you'll see that after 10 years, it's likely that only around about 20% of first tier tribunal decisions will have actually been cited. However, after 10 years, you have like 60% of other court decisions cited. So 40% are uncited after that period, whereas for first tier tribunal decisions, 80% are uncited after that period, or published decisions, 80% are uncited. So that's unsurprising, really, because decisions are allowed to be appealed to a higher level because they're of a greater public importance. And so we'd expect that the higher court's decisions would be more likely to be cited. It's interesting to note that it's really after 2 years, if a case is going to be cited, more likely than not, it will have been cited after 2 years. And then it sort of plateaus. After 4 years and 10 years, if a case hasn't been cited after 4 years, it's very unlikely that it will be cited in the next 6 years. And so if it's going to be cited, it will be cited quite soon. That's what the survival estimates tell us here. Then what I was going to talk to you about is the hazards model. So what we graph here is the survival function. The hazard is the likelihood, essentially, that if a case hasn't been cited by a certain point, it will be cited then. And so in death, which all of these are based on, if you haven't died by year 2, that you will die in year 2. And so what we can then do is look at various features, how they increase or decrease the hazard rate. And so this is what these estimates are all on. The effect on the hazard rate, which then, of course, affects whether you survive or not at that point. But we're not estimating the hazard rate in this model. We're estimating the effect that certain things have on the hazard rate. So I'm just going to show you what perhaps is self-evident in a way, that more complex cases are likely to be increase the hazard of being cited. And so how do I measure complexity? Well, I've measured it by who HMRC, first of all, by who HMRC use as their representative. So HMRC have limited resources. And so for the more complex cases, they will use a Queen's Counsel, or obviously now KC, but the data is old. And then we also have a panel of lawyers instructed by HMRC, and they're graded A, B, and C, and the C being the most junior, and they're paid less. And so for those slightly more complex matters, HMRC will use the panel in that order. And then if something isn't complex at all, they will actually send their officer, either the inspector or a employed presenting officer to the tribunal. And there are a number of cases where there's a barrister instructed who doesn't appear to be on the list, and that's those other cases. It's these numbers that were important. And you see here, this tells us whether it increases or decreases the hazard, this exponential of the coefficient. So it increases the hazard and multiplies it by 1.29 if a Queen's Counsel is used. If the A category is used, that's the reference category, and that's 1. And so a Queen's Counsel, as opposed to an A panel member, multiplies the hazard, i.e. by 1.29, it increases it by about 29%. So whereas if the B, as opposed to the A, reduces the hazard, the B then multiplies the hazard by 0.76, i.e. it reduces it by 24% effectively. And so it's as you would expect, pleasingly as you would expect from my perspective, that essentially the more senior HMRC's representative, the more likely a case is going to be cited. Maybe it's self-evident, but when I gathered this data and tied it into the data set, it took a long time, and some people questioned whether or not this is a good measure of complexity, but it appears to be so. Similarly, the story is the same for the length of the hearing. And the reference category here is a hearing of 0 days, i.e. a hearing that's done purely on paper. But of a hearing of 1 day as opposed to a paper case where there is no hearing, it multiplies the odds, it multiplies the hazard by 1.69, i.e. it increases it by about 70% of becoming a cited precedent. And if a hearing of 5 or more days, it multiplies the hazard by 3.8, essentially. And so the longer the number of days hearing, the more likely a case is to be cited as authority. Similarly, longer decisions. I've divided them into 4 quantiles for analysis. So the median decision is 4,000 words in length. The lowest quarter is below 2,300 words, and the top quarter is over 7,300 words. You'll see the longest decision, it's very long, 167,000 words. And the longer the decision, generally, the more likely it is to be cited. However, it partly depends on where the length comes from. And if that length comes from just padding from quoting from earlier decisions, then that isn't necessarily the case. So again, I've told you, I was able to see the percentage of a decision which is just quoting earlier decisions. And it ranges from the maximum a decision quotes from earlier decisions is 96% of the decision is just quoting earlier decisions, i.e. that's the sort of template that a judge has probably used and quoted from his earlier decisions. The median value is 13%, is quotes from earlier decisions. And the top quartile is 22.6. The first quartile is 7%. So, as I say, dividing it into 4 categories. And if I do that, it's only really the top category that is statistically significant and makes a difference. But for that top third quantile, top third quarter of decisions that are longer than that top third, then they are likely to the top third are more than 22% of it is quotations, and they're less likely to be precedent. And then I put it all together in a regression. So that was looking at each in isolation. These are putting all the coefficients together, and they tell a similar story. So just to conclude now, as I say, it's all part of a much bigger project I'm writing, a book on data science applications in tax litigation. And so what I do in the book is there's an introduction. I talk about the areas in which are litigated. I talk about a bit about how you measure complexity that I've just talked to you about now. I look about which appeals go on to further levels. I also talk a lot about, or a fair amount about delay, which is a major issue in the UK, especially in the promulgation of decisions, which can take up to 2 years. I look at which cases are cited, I look at which cases are quoted, and I talk about the style of judgments as well. And there's a chapter, a quite theoretical chapter on tax risk, and a more empirical chapter looking about who wins and the extent to which we can measure risk, and a conclusion that brings it all together, and with lots of the technicalities put in methodological appendices. It's largely written, and I hope to get the manuscript finished by mid to early summer, I hope. And so thank you, and I'd be delighted to answer any questions that any of you may have for me. Thank you.
Thanks very much for that, Michael. It's really interesting, and it's quite fun for me, I have to say, to be in a tax law presentation where we see regressions on the screen and not just a tax economics presentation, which is usually where I see that sort of work. I hope people aren't too daunted by that, but actually Michael can answer lots of questions on that anyway. So now very happy to open it up for questions. What I might do, Michael, perhaps you could stop. Actually, we've got your screen. I might just make it a gallery. Just a couple of things before we go on. And I see there's a couple of comments in the chat as well, so I'll come to those. First of all, thanks very much to the Tax Bar Association, which I forgot to mention up front, for jumping in and gamely co-hosting and promoting this pop-up webinar, and then for those of you who've joined us at such short notice to do so. So that's really wonderful to be working with the Tax Bar Association. And yes, secondly, to then say, let's kind of go ahead and manage some questions. So Michael, you can see the questions in the chat as well. The further thing I need to say, admin thing, is I have recorded the seminar. It is only recording at this stage on my own computer. So I will have a chat with Michael. I'm sorry, I should have alerted people sooner. The recording, I think, with the agreement of Michael, will only be of himself at this stage. So we won't, if we do end up publishing it, we won't be publishing individuals on that recording. So, Michael, I've noticed that Ben Lancaster has asked a question in the chat: what size of data set is needed for analysis of this sort? So obviously you've got a very large data set and you've explained how you put that together. So is it likely that there are enough Australian authorities to do similar analysis? You might want to comment on that. And then I noticed that Noel Baharis has a question there, or a comment in the analysis. Is there a statistical link between the number of cases cited and success of HMRC, which is an interesting causal link that would be interesting to be drawn. So why don't I throw those to you now, Michael? And others, if you'd like to ask a question in the seminar directly, please feel free to raise your hand. Otherwise, use the chat is fine as well.
So I think, yes, there are enough cases in Australia to do something similar. And indeed, I have been working a bit with some people at UNSW who are working on a similar project, Bin Tran Nam and Michael Walpole. And so there may be not. This is more in relation to the who wins side of things, but I think it could be expanded into the other things as well. So yes, and in relation to the cases cited and win rate, I've not actually put the two things together, but I could quite easily, not now, instantly, but after this, have a look at that and find out whether that there is. I'm not sure what the what necessarily the causal link would be. The thing that springs to mind initially is that I would expect on lots of HMRC's wins will, to my mind, be on quite simple matters, that if a taxpayer was well advised, they would not pursue unless it was purely delaying. But a taxpayer may not be well advised, or they may just be quite ideological in pursuing something and so do it. And in those cases, they're quite simple, and so there wouldn't be that many cases cited. And on where there are lots of cases cited, it's probably a more borderline issue, and so closer to a 50-50 win rate. Now, in the UK, actually, there is, unlike the data in Australia that Miranda's done some work on, where the something still a larger win rate for the ATO. But in the UK, we have something like a 90% win rate for HMRC. And so this is a massively high win rate. And as I say, I think it's partly due to there being lots of very unwinnable cases being pursued by taxpayers. And in those very unwinnable ones, I think you would find there is fewer cases cited. But I haven't done that analysis, so that's slightly speculation.
That's interesting to think about that connection and whether you could draw that. Actually, yes, I can do a little plug. It's great to know that the University of New South Wales is doing more research on this. I did do a paper that was about the federal court, so not about administrative appeals tribunal, so not the first instance, unlike Michael's work, which went into a recent book on the federal court at 40 years, sort of anniversary a few years ago, where we looked at the number of first instance and full court decisions and then win-loss rates in a more superficial and not quite as sophisticated way as Michael is doing, but some of that same analysis. So if people are interested in that paper, certainly happy to share that. It's an interesting question that, so Noel's just followed up with the comment that if the HMRC is less successful in instances where lots of cases are cited, could it be that they've not considered the issue appropriately? I guess you could sort of say, yeah, what are the learnings for the Revenue Authority or potentially for taxpayers if with those sorts of win-loss rates and with in terms of citation? Michael, you might want to respond to that, but I've got a sort of observation, I guess maybe a question for you as well. I was interested in the citation rates, that curve, the red curve and the blue curve, where you present the citation rates of first instance and then Superior Court decisions. Not surprising, as you say, that the Superior Court decisions are obviously cited much, much more. But it sort of does show that actually as many as 40% of Superior Court decisions are not cited, at least in your data, in the 10 years following. I don't know whether you've got any comments to make on that, whether that maybe is just inevitable because some cases are odd or don't get heard again or are very unusual.
Yeah, I mean, I think that's some cases, there are even very odd sort of House of Lords stroke UK Supreme Court cases that haven't been cited, that may be on particularly niche accounting issues, where often, sometimes cases have a lot of money turning on them. So there will be a point of public interest in the case being heard, because there will be similar taxpayers in a situation then, or just this one case may have an awful lot of money behind it. But then that settles an issue because it wasn't about a point of principle, but an issue of construction of legislation that no longer applies and no other taxpayer is facing. But yeah, even 40% is quite a lot to not have been cited after that period of time. So yes, it does seem as though, again, when we're asking, is there too much litigation? Have too many cases been given permission to be appealed? The answer may well be yes, especially the interesting thing will be, again, which I've not run the analysis on, when cases are decided one way and then a sort of flip-flop between different levels of appeal, showing that that the case was less certain to be decided that way. Whereas you may have a case that is decided by the first instance tribunal, then the appeal tribunal, and then the Court of Appeal, all in the same way. And so then is that one case which is decided all in the same way less likely to be cited going forward, because it was just certain, and maybe it was appealed because of the amount of money turning on it, rather than reconciling any ambiguity in the law. Yeah.
Noel's just following up. Yes, about Indurapilli, which is not a matter that you would be familiar with, Michael, probably. But there was some controversy about the tax office taking the view that they did not necessarily feel bound by decisions of a single judge. may not necessarily wait for a full court to sort of take a different view. It is an interesting issue.
Yeah.
Can I invite other questions or comments? We've still got a bit of time. Another question there in the chat from Ganesh. I think I said, can the number of quotations of old judgments in recent cases be used as a measure of guidance value? I'm not quite sure. I'm not quite sure what you mean by instead of hits there, Ganesh, but Michael, perhaps it is kind of an interesting question. What about old cases being constantly recited? Is that something you're looking at?
It is. And one question that I'll be looking at as well is the extent to which quotations are they just because the language is a bit sparky, essentially? And so sometimes you can obviously cite a case and summarize what it's about without necessarily quoting from it. And yet, do some phrases from earlier judgments somewhat spark the imagination? Phrases, for example, I can measure the use of adjectives and things like that in it. And is it therefore these lively judgments that are cited, or sorry, quoted? And then that again turns on this issue about judgment writing there. To what extent does a lively style of judgment writing make itself a more powerful authority going forward? Because then you're more likely to cite and quote it rather than a judgment that is more sober, settled in its tone.
I don't know whether the UK law is the same as in Australia, where we have these famous phrases, appropriate and adapted to or incidental and relevant for deductions, for example, that come up again and again. I guess the similar matter you might be able to search some of those key tax phrases in future and see how often they appear.
Exactly. In the UK, those phrases are often legislation. And so I've got that with the quotations from the legislation. We tend less to have sort of short phrases that are sort of glosses coming from cases. It's in tax. Obviously, in other areas of law, like the law of negligence and so forth, we do have judge-made law creating these short tests. Where that occurs somewhat more is areas of statutory construction, where, for example, Arrowtown, I know it's a Hong Kong case, but we have the test in that cited quite with regularity. But that's probably the small areas where you have these short phrases that sort of spark the imagination being cited.
And I think you recall there's another comment in the chat I'll come to in a second, but I seem to recall in your and my conversations before the seminar, you were observing that actually it was some of the case law about how one goes about interpretation, or even how about the process of a case sometimes, that are the most commonly cited decisions, rather than what we would think of as a substantive tax law case or issue, but actually the interpretive aspects or procedural aspects.
Exactly, and this crops up to one of the questions in the chat here about the nature of VAT and the European VAT as opposed to the Australian VAT. And so a feature of the European VAT is that there are these general principles of EU law which underpin it. And so, for example, we have the concept of fiscal neutrality, but that concept derives from a general principle of EU law of equal treatment. It's not written in the directive per se. And so there we have these lots of the cases that are most frequently cited in VAT are all trying to pin down and explain general principles of EU law. such as proportionality, such as legality, legal certainty, fiscal neutrality, which, as I say, is a sort of offshoot of equal treatment, and abuse of right, which is the avoidance doctrine of EU law, essentially, because the Ramsey approach in the UK doesn't apply to VAT, because it's a domestic rule of statutory interpretation. We need to look to the EU one of abuse of right. And so there, it is the sort of general principles that are the ones underpinning the case law in VAT that's cited the most, not about specific interpretations of words in statute.
I certainly think Australia's GST tends not to have these, reference to these underlying principles, but the litigation's all about sort of the statutory terms or specific aspects of the statute or categorisation disputes. Actually, just on that, again, when you and I were talking about Brexit and the UK drive to remove all references to EU law and principle from the statute book, people here might be interested as to when that's going to happen. I don't know whether you might want to briefly comment on that. And does it relate to VAT as well, given that the VAT is consistent with the EU approach?
It does. And so it's by the end of 2023 that unless EU law is specifically incorporated into domestic law, then it will no longer be part of the UK law, including these general principles. We do have a specific piece of legislation that has incorporated abuse of right, which is although the way it's done it, it's not clear that it will be actually preserved post 2023. And so, but that's the main principle that the government relies on. And so it's likely that they will include that. But the others, which have generally been used against the government to stop them doing things like retroactive changes to limitation periods, are, I suspect, likely to go. But then we do have general principles of the common law, which may do some of the same work, but they can't, unlike general principles of EU law, which are supreme and can trump domestic law. The common law can't trump statute. It can only provide the interpretive framework through which judges view statute.
Yes, well, that would be much more similar to our situation where we have that statutory supremacy. Few more minutes for questions, I guess, while we're waiting to see. Oh, there is another one. There's Steve. I've got a couple of more to go as well, but thanks for that. Is there any correlation between complexity of the legislation and numbers and subsequent citation? I must say, related perhaps to that question by Steve, I don't know what other people in the room think, but a median number of 3 cases cited, even at the first instance tribunal level, I don't know, anecdotally seems quite low to me. I would have thought in Australia that even, first instance tribunal decisions, depending on the area, of course, in some areas of tax law, there's almost seem to be no cases, and so you wouldn't. But in other areas, there'd be quite a lot of cases one would cite. So perhaps thinking about that issue as well.
Yeah, I mean, it depends on how we judge complexity as well. So if the complexity is caused by the legislation sounding simple but applying standards, then often we do have a lot of cases cited to try and essentially codify those standards. So what is an employee, what is not an employee, what is trade, what is not trade. And so the legislation on its face is quite simple because it's used words that everyone can understand. But then those cases are needed to then flesh out those words. But then we can have very complex legislation, which is essentially a long code. Like in the UK, our residence test for individuals is now like 30 pages or, a very long, complex set of rules. But when courts apply that, they don't need to cite cases because it's all there using a code that they can understand. And so it slightly depends on how we measure complexity. Again, I've not done that bit of the analysis, but my suspicion is for legislation that uses adjectives, what's reasonable and things like that, then you get more cases cited.
Actually, those two areas, what you're calling trade, are we in a business or not, or an enterprise for GST, there'd be cases there. And of course, residence is a really interesting example given our current situation here, where we do have a statutory definition, but not that many words in it, and an increasing number of cases, and sort of potential uncertainty. And then a recommendation to codify, sort of along the lines of the UK, which might produce the opposite kind of complexity, legislative complexity, rather than case law. I don't know, as a barrister, whether you ever dealt with I suppose you were doing that before that definition of residence was changed.
Yeah, so we haven't had that many cases on the statutory residence test litigated. So it's, I think it has quite foreclosed much litigate. I mean, there have been some. But.
Yeah. I must say that the paper we did on the federal court, for what it's worth, we did do a sort of look at substantive topics in dispute in single judge and then appeal court, and by far the majority of the cases are on ordinary income and general deductions, of course. So those are our kind of standard principle, standard provisions, I suppose, and that's where, as much as 60% of the cases are on those provisions. Any final questions? Or I'd also turn to you, Michael, and ask if you had any final kind of comments you'd like to make about where this is going. Or I have a kind of a general question. Obviously, it's very interesting, and there's a book in it for sure, all this new methodology and the specific things we can learn about the cases, the win-loss rates, citation processes, judgment writing. Do you see this as really game-changing or really extra valuable, either for improving the system as a whole or for taxpayer counsel, or where do you see the work going?
I mean, I think it's really valuable in terms of for the system as a whole in understanding the allocation of resources. And so understanding the extent to which it's valuable for cases to be litigated, because to litigate cases costs HMRC a very large amount of money, and that finance the courts and tribunals costs a significant sum. So to the extent to which it's valuable, especially to have 4 levels of appeal, as we do in the UK, and through which cases can be litigated. And I think also an understanding of how analytics can work. I can imagine in some years, we see with ChatGPT now, the ability to have pleadings, for example, written by computer, and that. I think that these sorts of data sets will be used far more commercially in 10 years' time than they are now, in the modest way in which I'm using them. And
do you think that would increase citations, because you've got potentially a sort of AI trawling a database potentially of case law?
I think that would potentially lead to judges limiting the citation. So it's really interesting to compare in different branches of the UK's tribunals. So in tax, we allow anything to be cited that has been published by the tribunal. But in immigration, for example, they don't even publish any first instance decisions. And in the appeal tribunal, their decisions can only be cited if they are reported and so allowed to be cited. Most of their decisions aren't reported to be cited. And so whether or not too many, this again is the question of resources, whether or not the tribunal should be releasing so many decisions at the moment. And so there's generally a feeling that it should always report decisions when HMRC loses. because if HMRC's pursued a line that's wrong, then taxpayers should know about it because they may be in a similar situation. But whether or not all the cases where HMRC wins need to be published on the website or not, or whether there's too much information overload, for example. So I think all of this does have the ability to inform practice going forward.
And perhaps just referring to sort of final comment or question in the chat there from Piotr, perhaps also inform HMRC approaches to litigation, not just taxpayers. I mean, I was pretty struck by the 90% win rate that you refer to. We've talked about that as well. Certainly in the tribunal, the revenue would have potentially a higher win rate than 50%. And in our look at the federal court, we found a sort of more than 50% win rate, but it was moderately balanced in terms of decisions that were actually reported. So Piotr sort of says, if it's not valuable to litigate cases, what's the alternative, and how would this affect HMRC decision making?
Yeah, well, the alternative is settlement of cases, and so, or not pursuing particular cases, but clearly that suggests that the very high win rate by HMRC suggests that they may not be pursuing all cases where there's only a 50% chance of them winning or losing. And so that there's some like law and economics literature called the Priest-Klein hypothesis in the US that suggests that essentially a very high win rate by someone is caused by them being too risk averse or very risk averse. Two is a value judgment. But it may well be that HMRC at the moment are actually choosing not to litigate a quite large number of cases already. So it would just be a continuation of that.
Yes, I sort of thought, well, maybe there should be more things being tested to make the law more certain in some areas. Well, look, thanks very much, Michael. We've come to the end of our time. Thank you, everyone, for joining us and staying with us. We'll listen to a recording and liaise with Michael. And if we think it's of value, we will make that available and let people know through the Taxpayer Association as well. So thanks a lot, and good evening, everyone.
Thank you, Miranda.